Okay, welcome everyone. So we're going to talk about human rights and how it relates to, uh, but more importantly, medicinal cannabis. If an employee uses recreational marijuana, there is no need for an employer to accommodate that. An employer does not have to accommodate someone's recreational use of marijuana. An employer does have to accommodate the medicinal use of marijuana. And why is that? Well, it's because an employer cannot discriminate based on an actual or perceived disability. So the use of medicinal marijuana may be treatment for a disability. And also the Supreme Court of Canada has recognized that drug addiction may be considered a disability, and they've confirmed that. And so, like I said, the use of recreational marijuana does not have to be accommodated. But if an employee is addicted to, sorry, I should correct myself. The use of medicinal marijuana does have to be accommodated. The use of recreational marijuana does not have to be accommodated. But if an employee is addicted to recreational marijuana, that is something an employer may have to accommodate in the workplace. And so the next question is, well, how far does an employer have to accommodate? And if we have any kind of employment law experts and HR people here, you're going to know what I'm going to say next. It's an employer has to accommodate to the point of undue hardship. So what I tell employers is it's not just regular hardship. Okay, so we're going to talk about what this means and how you accommodate an employee who has a disability, who needs to use medicinal marijuana, or has an addiction, which is recognized as a disability. Employers will have to experience some hardship. So there's a recognition in courts and in the Human Rights Tribunal in Ontario that there is some hardship the employer will have to undergo. If it's undue hardship, the employer does not have to accommodate the employee. Now, how you reach that point of what is undue hardship and what is not is something that's litigated fiercely in court and at the Human Rights Tribunal. And so if an employee requires accommodation in their work because of, like I said, the use of medicinal marijuana to treat a disability or addiction to recreational marijuana, the three things that an employer is going to look at are the cost of the accommodation, any health and safety reasons, and source of funding. Now, the source of funding really only relates to government, related and government arm's length organizations, and typically for most, and for private employers, the source of funding doesn't really come into play. So we're really talking about the cost to the employer, whether it's undue hardship or not, and whether there are health and safety concerns. And from my experience, accommodating employees regarding cannabis will really come down to health and safety. There's going to be health and safety concerns with regards to whether an employee's use of medicinal marijuana would bring about any health and safety concerns for themselves or for anyone else in the workplace. So, of course, we always consider the cost and the health and safety of it. But what we don't consider are what I have listed there. So when you're accommodating an employee for medicinal marijuana or an addiction, we don't consider business inconvenience. And that's something that I know a lot of employers talk to me about. Well, it's just easier if, for example, if we just don't have them in the workplace. Well, that might not be an appropriate reason or an appropriate accommodation. You might say, well, my patients or my customers or my clients, they would prefer not to deal with that person, or there's a really big hit to the employee morale. It looks like this person is getting special treatment. Well, the law recognizes that some employees are entitled to special treatment, but employee morale is not a factor in whether you can accommodate someone who requires the use of medicinal marijuana. And so that's kind of a general overview of how an employee, or what steps we look at, what steps we take in order to accommodate someone. And the accommodation process, what that all prompts is the commencement of the accommodation plan, and properly and reasonably accommodating that employee. So an employer not only has an obligation to provide reasonable accommodation to an employee, they have a duty to provide the proper procedure in accommodating an employee. And so if an employer does not follow the proper procedures, the Human Rights Tribunal says they will have discriminated against the employee because they didn't follow the proper procedures. And so in keeping with that, I wanted to review some obligations of employees in requesting and receiving accommodation. And I think this is an important part of this presentation, because if there's an employee who says, well, I can't do X because I use medicinal marijuana, or my use of medicinal marijuana prevents me from doing this, this is what employees are obligated to do in accommodation. So number one, they have a need to disclose, they must disclose their need for accommodation. And that's been made clear in cases at the Superior Court here in Ontario and in the Human Rights Tribunal. Employees have an obligation, and where an employee does not disclose their need for accommodation before they unilaterally use cannabis. And we're going to talk about a case, Tugboat Annie, which is one of my favorite cases. An employee, if they don't disclose their need for accommodation, the employer isn't aware that they need to provide that accommodation, and there's no analysis that has to take place. Now, there is a flip side to that, and I'll mention it as a little asterisk. So like I said, an employee must disclose their need for accommodation. But if there are so many red flags for an employer, if there are, and this would probably, if we're talking about someone who's dealing with an addiction, if there are so many signs, let's say there's some erratic behavior from the employer, from the employee, and their coworkers have mentioned they aren't the same person, or they're taking frequent, very frequent breaks. There might be some misconduct. They might be coming in late, leaving early. There is an idea in human rights law that an employer has a duty to inquire as to whether or not a person needs accommodation. But that would only be where there are these red flags, and it's so obvious, it would be obvious to a reasonable person that the employee requires accommodation. Okay, so it's definitely a two-way street. I've been saying that for years. Accommodation is always a two-way street. But more important, the employee still has they have a requirement, an obligation to disclose their need for accommodation. The employee must also provide all reasonable about their need for accommodation. Now, what is reasonable information? It's whatever the employer needs to determine what the employee's prognosis is, and frankly, what their job limitations are. An employer is not required, they're not really able to ask for a diagnosis. So what I tell employers is it's always prognosis, not diagnosis. How long will they require a certain accommodation, and what is the impact on job duties and job tasks? And normally that information comes from a registered health professional. Typically it's a doctor, and I've seen other notes from occupational therapists or chiropractors. So I don't limit it, my receiving of doctors' notes from simply family doctors. I've seen 50-page medical legal reports from lots of health professionals, and so whatever information is reasonable, that's the information the employer is entitled to request. If the employer doesn't get reasonable information, they should request it again. If they still don't get it, they should request it a third time. And at that time, they should be warning the employee, if you do not provide this reasonable information, the employee will be seen to not cooperate in the accommodation process. And that is the grounds for a for-cause dismissal. Okay, so that skips ahead to my fourth point there. An employee is required to cooperate in the process. And I've dealt with so many employees who have said, well, I'm just not going to give you, I don't want to give you any more doctor's notes. You have my one-liner doctor's notes, and that should be good enough. And there's a case, again, one of my favorite cases involving, sorry, the name just escapes me now. It'll come to me. It was involving an employee at an employer, and the employer just repeatedly asked for reasonable information about the employee's need for accommodation. The employee didn't provide it. The employer said, if you don't provide us this information, you'll be terminated. The employee was terminated. She sued at the Human Rights Tribunal, at Valley Village, sorry, Mistash Valley Village at the Human Rights Tribunal. And the employee sued, but the employee lost because she didn't provide the reasonable information. The employee is also obligated to seek and attend their treatment. The employer can't force that treatment, but they should, take reasonable steps to help themselves. And lastly, the employee has to accept reasonable accommodation. Employees are not entitled to their perfect accommodation. So they might say, well, I use medicinal marijuana, so I just want to do only administrative duties. But their job is, they may be working on a line, and they've never been trained in any of these administrative duties. There are no open positions for administrative duties, but perhaps the employer can accommodate them, with a modified schedule, maybe modify some of their job duties. Maybe they can permit them to come in late or leave early, or simply give them unpaid time off. Those are all different accommodations that could be provided. An employee is obligated to accept reasonable accommodation, but what is reasonable is, it depends on who you ask. I also want to go over what employers are not required to do. So employers do not have to compromise safety in their office. They do not have to tolerate an employee reporting to work high. The employee still has to be able to perform their job duties safely. They don't have to keep an employee in a job without accommodation. So if it's reasonable to accommodate an employee, they should be accommodated, but they don't have to keep them in a position without accommodation. My third point, an employer doesn't have to pay an employee for not working. So an unpaid time off, unpaid leave of absence is an acceptable accommodation. It's going to be temporary. It's not going to last forever. We're going to, get updates from the doctors to understand what the prognosis is, but they don't simply automatically have to be paid for not working. And it's not up to the employer to enforce the employee's treatment plan. So if they have a certain treatment plan, the employer can't enforce it, but the employee should reasonably, help themselves. So this is one of my favorite tugboat Annie cases. This is out in BC. So this is well before legalization of cannabis. But this employee was a chef at Tugboat Annie's pub in the Lower Mainland. He took it upon himself to smoke up on his break. He smoked marijuana on break. And the employer found out about it and terminated him right away because they didn't tolerate, the use of marijuana while at work. So the employee sued, and he went to the Human Rights Tribunal and said, well, I have a disability, I need to smoke marijuana. But the employee lost because for two reasons. One, the employee didn't disclose that obligation to it didn't disclose the accommodation to the employer. And number two, in the evidence that was in front of the tribunal, the diagnosis of the employee's disability came after he was terminated, and it came after he said he needed to use marijuana. So there was the only information available was that he was terminated, and then he had a doctor confirm he required accommodation. So the employee must disclose their accommodation in order to start that accommodation process. Another case I wanted to talk about, now this went all the way up to the Supreme Court of Canada, and the Supreme Court confirmed that it is appropriate in some circumstances for there to be a mandatory disclosure of addiction or the medical use of marijuana. So again, it is up to the employee to tell the employer, I use medicinal marijuana, it has this effect on me, I may require accommodation. And there, the Supreme Court considered a drug policy of that employer, and the Supreme Court found that it was appropriate for the employer to terminate the employee because they didn't comply with this reasonable policy that the employer had, not on drug testing, but it was a drug policy that you must disclose if you have a substance abuse, if you're, or you have an addiction. And it was very clear, and there was no discrimination found in that case. So that was my talk about accommodation, but I have been mentioning that, I mentioned health and safety, and it is still important for the employer to, keep safety concerns and the Occupational Health and Safety Act, or I'll call it OSHA, to keep those safety concerns in mind. So the law, the OSHA specifically states that an employer must take every precaution reasonable in the circumstances to, have a safe workplace. So, and that is quite broad. Okay, supervisors are specifically mentioned, and they must advise a worker of any potential or actual dangers, especially safety-sensitive workers. We're going to talk about safety-sensitive workers. So if there's a potential danger, if an employer becomes aware, through one way or another, maybe an employee discloses, let's say an employee is operating a crane, and the employer, finds reasonable information, or obtains information that they used medicinal marijuana that day, a supervisor may have a duty to inform the workers of that workplace to say, well, we need to stop, the operation on this day because I just found out that the crane worker used marijuana, and he's in a safety-sensitive position, and so we need to, stop the operation in order to investigate. The employer also has a duty to prepare and review their health and safety policy. That has to be reviewed at least once a year, and there has to be proof that it's being reviewed once a year. That goes hand in hand with the workplace violence, workplace harassment policy. And so I really encourage employers to review what their current policies are, and to ensure that they have their proper workplace violence, workplace harassment, and also accommodation and accommodation policies. Okay. Now, employees do have obligations for safety in the workplace as well, as it relates to cannabis. So employees have an obligation to work safely. If an employee is not working safely, they are in breach of the law. They're breaking the law if they knowingly work unsafely. Okay, and it's up to the employees to report any issues or hazards related to health and safety. That could include themselves. It could include someone else. So if there's an employee who's aware that another employee is smoking up on break, that employee has an obligation to inform the employer. So I was talking about, well, if someone, if the employer finds information that there is a potential actual danger, right, that goes hand in hand with the employee's obligation to report any issues or hazards in the workplace. Now, of course, that can't be abused, and the employer has to believe that it's reasonable and believable information. So that it works hand in hand in terms of workplace health and safety. It applies, and we've been hearing a lot in the news about certain industries and there being prohibitions on the use of cannabis outside of the workplace, and that would be for certain employees that are in safety-sensitive positions. And so I've mentioned it before. What is a safety-sensitive position? So not every employee is going to have a safety-sensitive position. So the most important part and how you determine someone is in a safety-sensitive position is if, and I have the definition here, there has to be direct and significant damage, or the possible direct and significant damage to the worker or other people in the workplace or the environment. But of course, you have to keep the context of the workplace, the industry, in mind. Okay, so like I said, not every employee is going to be in a safety-sensitive position. Generally, offices are not seen to be a safety sensitive position. It's employees who are working at heights. They might be working underground. They may have the health and safety of others as one of their main job duties. So that would apply to, let's say, flight attendants, right? Their main duty is to maintain the safety of the aircraft while it's in motion, and so any impairment by them could result in direct or significant damage. Now, there is a lot of gray area with that, so I really encourage you to speak with a lawyer if you're not sure if a certain employee is in a safety-sensitive position or not. If they are in a safety-sensitive position, then you may be able to enforce a more strict drug policy against those certain employees. And this also relates to accommodation as well. So I want to go back to that. There was a case from 2019 from Nova Scotia, or I'm sorry, Newfoundland, and that employee was in a safety-sensitive position. It was on a construction site, and he declared that he wasn't in the position yet. He declared he used medicinal marijuana daily, and he was denied the employment of a safety-sensitive position. And the reason why is because, and so, I should say he went through the arbitration process. He was a unionized employee, went through the arbitration process. The arbitrator said that it was not discriminatory for the employer to deny that person a safety-sensitive position. And the reason why was because there was no reliable test to determine whether an employee is impaired or not. And it would be undue hardship for the employer to find an appropriate test to determine whether that employee was impaired. So there's kind of a few issues happening there. So number one, the person wanted a safety-sensitive position and they didn't get it. Number two, it brings up a really important point with, alcohol. We do know when someone is impaired, and it's generally understood when that impairment ends. But the science is not currently clear on what impairment of cannabis is. It can stay in your system for a long time. I've heard up to 30 days or more. But does that mean that you're impaired for 30 days? So there's now this new level of vigilance that employers need to keep in mind, because if they don't know whether an employee is actually impaired or not, that employee may not be entitled to stay or to get a safety-sensitive job. So it's an important point. And the risk, if the employer messes up, the employer doesn't do their duty, there are fines and even more for an employer. So this is an extreme case. It involves a construction company from several years ago here in Ontario. Unfortunately, there was a workplace accident, and there was a high-rise construction project. There were 3 workers who had recently ingested pot. And some people, you may have heard of this, is in the Toronto area. Unfortunately, 4 people died and 2 people survived. And there wasn't enough safety mechanisms there on this high-rise construction site. And the Ontario Highest Court found that the employer wrongfully permitted its employees to be in those safety-sensitive positions. The employer, the corporation, was fined $750,000, and the president of the company was personally fined $112,000. And the project manager went to jail for 3.5 years. Well, he was sentenced to 3.5 years in prison. So this is a serious issue. Of course, in that case, it's a very serious circumstance, of course, wherever there's dealing with workplace accidents and workplace deaths. But there is liability for employers. Now, on the other side, we have an employer who, again, this is from last year, a case from the Ontario Human Rights Tribunal. And the employer had a zero tolerance policy on intoxication for anyone who's at the working at heights position. So this is a painting company. The employee was working 37 floors up, didn't have a tether, wasn't attached to the swing stage that he was on, and he was smoking cannabis. The employer found out, sent him home, eventually terminated him. The employee sued for discrimination, and the employee lost because the Human Rights Tribunal found that their zero tolerance intoxication policy on workers at heights was reasonable, and it was necessary to protect the health and safety of that employee, other workers, and the public in general. And and there are some other kind of nuances to that case where the employer, it was a proper policy on the zero tolerance. So we shouldn't always go to zero tolerance policy, and we're going to talk about that. But for this employer and this particular employee, it was reasonable. So the drug policies, it's important that employers have policies. As a lawyer, that's kind of something I say every day. And something that I'm telling employers now, it's important to have the policy in place before you think you need it. Because when you think you need it, you don't want to be scrambling if there's something urgent in order to determine, well, what do we do? Okay, so it's important for employers to understand all their obligations with accommodation and health and safety, and have the policies in place. Okay, so I think it's important to know the different definitions. You have to be able to define drugs. You have to define where the workplace is, define if the policy impacts any off-site conduct. If there's any other prohibitions, during breaks, when employees aren't working. And I think it's also important to define what does fit for work mean. If you have a statement that says employees must come to work and they must be fit for work, you have to define that and make it clear for every employee. And I think at the same time, when you have a drug policy, you should have the related policies in place, right? Perhaps a mandatory disclosure policy. If you use medicinal marijuana, you must disclose it. They don't have to disclose a diagnosis. The employer does not need to know why they use medicinal marijuana. They need to know that they use it and they require accommodation. They need to know what the prognosis is, how long they intend to use it, and how it impacts their job duties. And of course, like I said, accommodation, as we talked about, there should be a clear policy at a minimum, confirming the employer the employer recognizes its duty to accommodate. But of course, you made a policy, and then what? Right? You have to communicate the policy. You have to train everyone on it. It should be enforced, and it should also be reviewed regularly. If you're at a small business, you may not have a joint health and safety committee. You might just have a rep. If you're at a very small business, you might not have anyone responsible for health and safety except for the owner. And so it's important to undertake those tasks on a regular basis. Some other food for thought. This is from a CAA survey from 2018, right before legalization. And about 40% of people said, and this is from a different, I know I mentioned this before, about 40% of people said they've driven while high at one point. Okay, so I think it's important that these policies and that this issue is recognized as a real live issue in workplaces. I think it's also important to understand cannabis impairment. So we talked about what is, so I showed you some images of what cannabis is, but do we know what it looks like if someone is currently impaired? So these are some of the short-term physical indicators of cannabis use, cannabis impairment. This is from CAMH here in Toronto. So there's obviously an odor of marijuana, and I would encourage employers, if they don't know what marijuana smells like, they should know what it smells like, right? Because that you may be that's one, according to CAMH, that's one physical indicator of cannabis impairment. A person might have decreased concentration, they might have slower reaction times, their motor skills, so they're just kind of working a lot slower, and that might be visible, and it might be, readily apparent, it might not be readily apparent. CAMH talked about a distortion of sensory perception and cognition, and that is it might not be something that is, again, readily available to an employer, but it's not just the employer, it's the coworkers as well. There's an increased heart rate, forgetfulness, decrease in balance, and some of the, red eyes is another one that is common. But I caution employers, just because someone is drowsy or someone has red eyes doesn't mean that they're automatically impaired. And I think every example has to be looked at on a case-by-case basis, because there might be other reasons. And so I'm not saying employers should go around and try and interrogate someone just because they came in late and they're a little drowsy. There might be a reasonable explanation for it, and I really encourage employers to consider the entire context. Now, I want to talk about drug testing. Drug testing, there is no one-size-fits-all drug testing policy. Drug testing is a legal minefield in Canada, across in Ontario and in Canada, and it's been litigated all the way up to the Supreme Court. The Supreme Court essentially has found that any drug testing policy must balance workplace safety and employee privacy. Okay, and it's also really important the type of work that the employee does and whether it's reasonable for a drug test to be implemented on those employees. So there may be circumstances where an employer can require drug testing, but it's very constrained in Canada. And if your organization is thinking about implementing a drug testing policy, I would really encourage you to seek legal advice, because I wouldn't want you to get in trouble down the road. Now, you can definitely have a substance abuse policy and an accommodation policy. And your accommodation policy might say, like, as a mandatory disclosure of use of medical cannabis. That would be seen as reasonable. But I have a list of the types of tests, and there are many different types of drug tests. Pre-employment testing. So you can test that there are some circumstances that are quite rare, but they still exist, that you can test someone before they even work for you. If an employer has reasonable cause, so if they suspect that an employee is impaired, they may say, okay, we're invoking a reasonable cause under drug testing policy, and we require you to take this drug test. Some employers have a post-incident drug testing. Okay, if there's a significant incident, then we'll require you to take a drug test. There are such things called random drug tests. They are extremely rare. So I would, if that's something that you currently have or are thinking about, I really encourage you to get legal advice on that. And there's also testing that would take place after rehabilitation. So there, I mentioned that these cases have gone all the way up to the Supreme Court. Some employers have won and some employers have lost. And they may have thought a certain drug test is reasonable for a certain employee, but it's not always clear. So that's something definitely to think about. But that doesn't change, like I said, the obligation to have a policy on substance abuse or use of cannabis or accommodation in the workplace. So lastly, I want to talk about, how to protect, your workplace and the things that you can do. So number one, if you suspect impairment of an employee, if someone needs immediate assistance, call 911, okay? But after that, if you suspect impairment, you should look to your policies and see, and follow those policies. There'll probably be reports that you have to make, and maybe statements that you might need to take from other employees or supervisors, managers. So definitely recording, observations and incidents and events is going to be key. But it's important to be ready for all of this. And how does an employer be ready for it? Well, number one, like I've said, you have to have policies in place before you think you need them. Kind of like a plunger, right? Toilet plunger. You need to have it before you think you need to use it. And those policies, like I said, they're going to be, you'll have an accommodation policy, maybe a substances abuse policy, and a drug test, possibly a drug testing policy. And it might be very brief, but you might still choose to have one. And it's important to update those policies on a regular basis. Okay, and as the law changes, and employment law is a very very frequently changing area of the law, it's to update those policies. I would also say that employment contracts are also important for you to for an employer to be ready for what cannabis might bring for them. So and someone might ask, well, how do employment contracts play into all of this? Well, my opinion is it's always better to have clarity in an employment relationship than ambiguity. So there's a lot of push for things to be paperless, and everyone wants to be paperless. In employment law, we still need paper. We still need signatures, and we still need evidence that an employee understood and reviewed important terms of employment, and that also includes policies as well. And I tell all of my clients, I tell every employer, employees should see a copy of the more important policies. They should see it before they start working. Okay? They should also sign their employment contract before they start working, before their first day. Now that doesn't really relate to cannabis, but the policies, and I would say cannabis accommodation, vacation policy, those are more important, workplace harassment, those are more important policies that employees should see before they start working so that they fully understand. And if you need to rely on those policies later, you can simply say, we sent you a copy of the policy, you had time to review it before you started working, there's no reason why this policy shouldn't apply to you, and you can, if you need to discipline a certain employee for misconduct, it might involve, using recreational cannabis at work, you can know that those policies are going to be, upheld. We talked about educating yourself. I think it's important for companies to educate themselves and educate, their leaders. They need to know the difference between the use of medicinal marijuana and recreational marijuana. And we talked about the signs of cannabis impairment. There should also, there are also signs of cannabis addiction that look a little different than just simple impairment. And they should also know, any manager or an employer should know about their duties to accommodate, and frankly know what to say and what not to say. So I've already said, that diagnoses should not be requested. If an employee happens to declare a diagnosis, okay, we're going to treat it as confidential. But the employer should not demand a diagnosis for a use of medicinal marijuana. Be reasonable but firm. There are lots of ways for an employer to have, to be firm and to uphold, health and safety and reasonableness in the workplace, but they don't have to do it, violating human rights law or violating, any other laws. And like I've been talking about before, we can't forget accommodation. Accommodation is, it was there before recreational marijuana. It's there after recreational marijuana. So that's an important part of all of these discussions. So that is the kind of the end of my presentation, but I do want to save time for any questions. And so I'll see if there are any questions that have been written here. And if anyone wants to take some time now to type in a question, I'd be happy to answer it. So I'll give a couple minutes there. I can talk really briefly about, our benefits plans required to cover medicinal marijuana, medical cannabis. And so that's a very new area of the law. And I would say, so there's some recent cases that suggest that it's not discriminatory if an employer wants to exclude medicinal marijuana. There could be valid reasons for that. And so that's something to consider. And I'd say what's also on the forefront in terms of human rights law is, the use of recreational marijuana and how it relates to creed. And you may have an employee who says it is part of their creed to use recreational marijuana. And therefore, that would be kind of an exception to what I said before. That may require the employer to accommodate the use of recreational marijuana, but it's not because of the use of marijuana itself. It has to relate to the employee's religion or creed. So that, I would say, is right on the forefront. I haven't heard of that argument being made, that specific argument being made at the Human Rights Tribunal, but there are some, on other areas of human rights law, veganism is becoming, is pushing the boundaries of what is included in creed and in human rights law. And I foresee that there are going to be employees out there who say, I need to use recreational marijuana because it's part of my creed, it's part of my religion. And what I would say to that is, to be very brief, the employee still has an obligation to disclose what their accommodation is. The employer can request all reasonable information, even if it's regarding a creed, it can be requested. And there's an accommodation plan that can be prepared. So obviously, we're not going to get a doctor's note. There might be, a person of faith might give a note, but that still needs to be reasonable. And if it's not reasonable for that employer, they do not have to permit it. And the reasons would be if it would be undue hardship for the employer to recognize, that particular accommodation. So that would be kind of in the forefront of what's pushing the boundaries of employment law as it relates to cannabis. So I don't think there are any questions here. So I will turn it over to Claudia, and I thank you very much for your time. I'll just put up my contact information there, my mugshot, of course. If you do have any other questions, you can reach out to myself or to the organizers here, and they'd be happy to give you a copy of this presentation. I believe it will be recorded and put online if there's something you wanted clarification about, and I'd be happy to answer any other questions regarding cannabis.
Yes, so thank you, Jonathan, for that wonderful presentation, and thank you, everybody. So that's all the time we have for today. There was one question I saw, and it was regarding getting a copy of the presentation. So we will be distributing a PDF copy later today following the presentation. That way, in case anybody missed anything, then you can refer to that later on. So we ask that you take a few minutes to answer today's exit survey questions after, and let us know if there are any topics that would be of interest to you in the future. And then for more local, relevant, and timely labor market information, you can be sure to follow us on our LinkedIn. It's Working in Peel Halton. And so on behalf of myself, Jonathan, and the entire Peel Halton Local Employment Planning Council, thank you so much for joining us and taking the time to view this webinar. I know the information is very relevant and very useful for all of you in your workplaces. It was a pleasure spending this hour with you. Have a great day.